Welcome to Judica County. I'm your host, Taylor Scruggs-Smith, and I'm here with Cassandra Nicholas, and we are both attorneys with Whitaker and Hamer, your law firm for life, with offices across the state of North Carolina. Today we want to touch on a particular topic in estates, and again, this is an area that Cassandra practices in primarily. So one of the questions I think we get a lot of times, and is probably a Googled question a lot of times, is do you even have to open an estate when somebody dies?
Well, like with all legal questions, the answer is it depends. Most people do need to open an estate, in my experience, but that could be a self-selecting group that are reaching out to an attorney. Primarily, an estate needs to be opened when there are assets that are in the name of the decedent solely that need to be transferred somewhere to someone. So the only way to do that, to get the authority to transfer bank accounts and vehicles and sometimes even houses, is to open an estate with the clerk of courts.
So I know one time a question I've heard from potential clients before is all they have to transfer is a vehicle. Do they still have to open an estate?
That also depends. This is county by county, but in Wake County, North Carolina, the limit is $5,000 for all of the vehicles that can be transferred without opening an estate.
Okay.
So if it's an older vehicle that may be worth less than that, it's just a DMV form, and easy peasy. But as most vehicles are more than that, most people do need to open an estate to be able to transfer that. If the total value of the estate, if the estate is just vehicles, is over that $5,000 but under $20,000, we can do an abbreviated procedure. It's a small estate. So it's still opening an estate, and in that case, the personal representative is called a collector, and it's a little bit quicker, a little bit cheaper, but that's just one way to do it.
So it sounds like there's a lot of calculations that need to go into it. So it sounds like they need to consult with you before.
Yes, I would absolutely recommend consulting with an attorney, because there's a lot of nuance, a lot of statutes determining exactly what dollar amounts fall into which estate category.
And how does, I know some bank accounts have where you can put a person, like if I die, this person gets my bank account. Does that still have to go through an estate?
So if a bank account is joint with right of survivorship, that is automatically owned by the other joint owner of the bank account. So if that's all of the decedent's bank accounts have someone else as the joint owner with right of survivorship, none of those have to go through the estate process.
Well, these are all wonderful things to know, and we really appreciate your time. We thank you for joining us on this episode of Judica County. If you find yourself in need of legal assistance with estate probate law, give us a call at 919-772-7000 or reach out to us via our website, wh.lawyer. Again, we are Whitaker and Hamer, your law firm for life.